Aging Insight, empowering you through the aging process.
My name's Alexander. I go by Alex, so if you guys want to ever say hi or drop me a line, you can call me Alex. Like Marty said, I've been with Ross and Schulmeyer right around 2 years. So I've been practicing under John and Lisa, who, if anyone's gone to one of these deals before, has definitely heard speak. So I've been practicing under them, learning from them, and learning quite a bit. Today, I should say, if you have heard them talk before at any event at all, you might have heard some of the stuff we talked about, but you'll hear it from a different perspective, and if anything, we'll be reinforcing some really important information. Today's topic is the most important documents. Of course, we're talking about in the estate planning context. Estate planning, wills, planning for the future, powers of attorney, documents that put you in a position to be prepared for what might be coming down the line. Generally speaking, people will not do any sort of planning at all. I don't have the percentages on me, but it's pretty fascinating when you look at the numbers. You will find that a vast majority of the population, including the senior population, has done absolutely nothing to plan for their future in terms of power of attorney documents, wills. They just let it ride. And that's understandable in some ways, I guess. No one likes to think about bad things that could happen. John will put it this way. He says most people plan around what they hope happens as opposed to what could happen. So most people hope that everything's fine, so they don't do anything. But it's much smarter to plan for what could happen. And that's kind of where we transition into these important documents. First one I'm going to talk about is the will. I'm not going to spend a terrible amount of time on what wills are. Everyone has a pretty good idea, I think. Do I even need to ask for a show of hands? Has everyone heard of a will? Probably, right? Okay. So, what is a will? Basically, it's just a handful of paper with some words on it that say who you want to be in charge of your stuff when you're gone and who gets that stuff. Not that complicated. But in a will, you can get into very specific things about what you want to have happen to that stuff. And you can get into exactly who you want to be in charge, people that you trust. You can leave out people that you don't trust. I have some clients in my office currently who have been taking care of one of their children throughout their entire life, the black sheep. Thousands and thousands of dollars. The other child is doing just fine, doesn't need their help. So they came in and they said, we want to make sure that the child we have not helped gets help from us or gets some money from us when we're gone because we've done everything for this other child. That would not be possible if they did not have a will or do some sort of specific estate planning around that. Because if you do not have a will, the law will dictate what happens to your stuff. And the law is very specific because it assumes what you want, right? It assumes that if you're married, you want your spouse to get a large percentage. Or if you have children, it assumes you want both of them or all three of them or however many you have to get equally what you have. And for those people, that's definitely not the case. They wanted it to be disproportionate. With no will, it's going to be equal. It will not follow what their true desires are. So they are wise to put something in place to make sure that that happens. Now back to what a will is. Like I said, it's just a stack of paper with words on it. It means absolutely nothing until you're gone. Technically, it's a valid document if you followed all the rules. It's witnessed, it's notarized, and all that stuff. But it has no effect until you're gone, right? And that stands to reason. You can change your will. You can destroy it. You can get rid of it. It means really nothing until you're gone. If I wanted to leave something in my will to someone, my nephew, for example, I could put it in there. I leave my favorite car. I only have one car, but I don't know why I said that, but I leave my car to my nephew. Okay. If he knows about that, he thinks he's getting my car when he's gone, or when I'm gone. What if I need to sell that car, though, to get some extra cash, to pay off some debts or something? Just because it's in my will doesn't mean I have to keep that car, right? I can do whatever I want with it. So even though it's in my will, it's still just a piece of paper with words on it, okay? You can change it, you can do stuff, you can do whatever you want with your stuff. But the will, sorry, is this okay? The will go ahead and pass on what you leave behind the way you want it to go. Common things that people are a little bit confused on about wills. I get people coming into my office all the time saying, I'm my mom's executor, or I'm my dad's executor, so I want them to go live in a nursing home, or something like that. Okay. No, that's not how it works, sir or ma'am. An executor is the person you name in your will to handle your business when you're gone. Just because you name someone as your executor and you're still alive doesn't give them any right to do anything at all while you're alive, because you can change that. And remember, a will doesn't actually have any effect until you're gone. So just because someone's named as executor does not mean they have any sort of rights, okay? That's a common misconception. Just because someone is named as a beneficiary in a will doesn't mean they have any rights to that property. Remember the example I gave with the car and my little cousin, or my little nephew, excuse me. He doesn't have any right to that vehicle just because it's in there. I can do whatever I want with that thing, okay? It's just what happens when you're gone, where your stuff goes. The only thing that a will controls or has any effect over, all right, is what we call probate property. Has everyone here heard of probate or dealt with probate even? Yeah? Okay. So probate is the process of taking that will after someone is gone and getting it validated. Because think about this. Say I'm gone. Some unfortunate accident, or fortunate accident, I don't know. Some unfortunate accident occurs and I die. I have a will. And let's say I also have some money in the bank. And I, in my will, say it all goes to my nephew or my sister. Let's just say my nephew. So he takes that will and runs up to the bank and says, look, I'm the guy on here who gets everything. Go ahead and release it to me. Anyone here know what the bank's going to say? No. They're going to say, sir, how do I know you didn't just create that will today and forge it? There's no proof that it's an actual valid will. So in order to get access to that, what my little nephew would have to do is take it through the probate system. It means you got to hire a lawyer, go in front of a judge, get the will validated. Make sure it's a true, real will, okay? And then once he's gone through that process, he can take it to the bank and go on and get the money released to him, whatever the deal is. So there's a little bit of a process when you got a will, and you got to go through probate. Again, the only thing that it deals with is what we call probate property. Probate property is pretty much everything you got right now, if I had to guess. But there's also non-probate property. Okay? We're not going to get too much into this, but I think it's important to discuss if we're going to talk about a will being an important document. I think it's important that we discuss what a will actually covers. Okay? Non-probate property, basically, is property that has a beneficiary attached to it, okay? Or a payable on death. So if you have a checking account at Regions and it has a $5,000 in it, and you have a payable on death person who's going to receive it when you're gone, they get it just like that, second you die. The will does not cover that. The will only covers stuff that has no one to go to. Okay? So if you had that same checking account but with no payable on death on it, or no beneficiary, there's no one for it to go to. So it has to go somewhere. So what does it go? Or where does it go, excuse me? Into your estate. All right? Y'all have been to estate sales or seen the signs. That's all stuff that didn't immediately go to someone, okay? Houses are generally going to be probate property. Cars are generally going to be probate property, otherwise known as estate property. Bank accounts without beneficiaries or payable on death are going to be probate property. If you have a will, your will direct where that probate property goes. And now we go all the way back to the point that I made, that if you don't have a will, you cannot control where that property goes. You lose the ability to direct where your stuff goes. And that's only important if you care where your stuff goes, okay? Most people do. Most people do. But I've had many people in the office, they're like, I'm gonna be dead. I don't care what happens. I'm gone. Whatever happens, happens. And that's fine if that's your call. But if you actually do care where your stuff goes, having a will in place is a really good idea because you, again, can direct where your stuff goes. And you can make contingencies. What if you got 2 kids? I leave everything I got to my 2 kids. Wipe your hands. That's probably not a good will. Because if one of your kids passes away before you, what's going to happen to their stuff or their 50%? In a will, you can say, I'll leave everything to both kids. But if one of them's gone, then I want their 50% to go to the grandkids, or to go to charity, or to go to whoever you want, or to go to the other kid. You control all that. You do not control that if you don't have a will. Okay? Will, basics. Got to have an executor. That's the person who's going to handle your business. Make sure it's someone you trust. Okay? You should also have a backup, because if there's not, then anyone can apply to be the executor. You never know what the future holds. If you just have one person named, something happens to them, probably a good idea to have a backup to step in. Okay? Every will has beneficiaries. Those are the people who are going to receive your stuff. So your will says who your executor is and who your beneficiaries are, and then you fill in the rest. What happens to it, if this, if that, if this, if that. That's the basics. Once again, just having a will makes sure that your probate property is directed to who you want it to go to, the way you want it to go to. Otherwise, you have no control. That's what makes a will so important. Okay. Now, remember I said wills only mean anything when you're dead, right? It's just a piece of paper with words on it while you're alive. That can be changed, so on and so forth. Terminated, you can get rid of it if you want to. Now, what about when you are alive? Now's when we get into what we call power of attorneys, all right? And there's a lot of misconceptions about these documents out there. I've heard it all the time in my office, all the time. So I'm going to clear up some of those misconceptions and explain exactly what power of attorneys are and what they do. Okay, we're in Texas, Arkansas and Texas, being a border town, almost identical in terms of the law, but we're going to just basically talk about it from a Texas perspective. There are 2 types of power of attorney, okay? We have a financial power of attorney, and we have a medical power of attorney. Okay, financial. If you ever see someone who has a form on it that says statutory durable power of attorney, that is a financial power of attorney. A power of attorney document only allows the person that you name to do what it says in the document. Nothing more, nothing less. So, if you ever hear someone say something along the lines of, well, I heard that so-and-so's kid had power of attorney and put him in a nursing home. Or I heard they had power of attorney and forced them to go do something they didn't want to do. No, cannot do that. That is not allowed. That being said, some people will take advantage of the fact people don't know that, right? And say, I got power of attorney, I'm making you go here, I'm making you do this. They don't have that ability. It only allows you to do what's in the document. And a good, solid power of attorney on the financial side pretty much allows the person that you name to handle all of your business. All of your business. Financial business. You got stocks, they can handle your stocks. You got bank accounts, they can handle those. You got property, they can handle that. You got retirement accounts, they can handle that. So on and so forth. Your stuff. Now we will run into situations where somebody will say, well, I'm not comfortable allowing somebody to do that. I go, okay, well then don't name that person. Pretty simple. If you have any reservations about giving them that ability to handle those deals that I just mentioned, don't name that person. It's got to be someone you trust. It's got to be somebody you trust to do right by you, all right? In a power of attorney, you, as the creator of the document, are referred to as the principal. That's the legal term. And the person that you name, or the people that you name, are called the agents. I like sports, so I use a sports analogy. You are the coach, and they are the players. What does that mean? Coaches, hello, does that work? Coaches are in charge of players, right? You are not giving up any power when you create a power of attorney. So let's knock that misconception out the window. If you create a power of attorney, you are not giving up power. So if I create a power of attorney and I name that same little nephew of mine as my agent or my player, that does not mean that he can take that document, wave it around town, and override all my decisions. That's not the power that I'm giving him. What I'm giving him is the equal ability to me to handle my business. Right now, I'm 36. I can handle my business. I don't need anyone to do it for me, but I still have a power of attorney. Because if something happens to me tomorrow, car wreck, something like that, now I can't pay my bills anymore. Can't pay my law school loans. That would not be good. That would be bad. I cannot pay them if I'm in a coma. I need someone to do that for me. So I have a document called a power of attorney that gives, this is actually my sister, my nephew's 7, so he's not going to be doing any of that. But my sister can handle my business for me, and she knows it, okay? That's why you have a power of attorney. She's not going to use that. I trust her implicitly with everything. She knows she could call up my bank and clear out my accounts, but she's not going to do that because there's that level of trust, okay? The power of attorney that I created allows her that immediate ability to act for me, so she can jump right into action if she needs to. There's another way for the agent or the player to jump into action, and that is only on my incapacity. I don't like that option personally because let's say I get in that car wreck and she can only do something on my incapacity. So she takes that document to my bank and she says, my brother's in a coma. I need to handle his business. They'll say, whoa, whoa, whoa. How do we know he's in a coma? You could just be trying to come in here and clear out his bank accounts. We need to know that he's incapacitated. So now she has to run to find the doctor, have him fill out some paperwork, present it to the bank. The bank needs to get it to their legal department to make sure that everything's valid, and then she could act. That could be 10 days from now. I don't have 10 days to get my business handled. I need it done now. So that's why I'm giving her the immediate ability to handle my business. I hope that follows. That is what we recommend at our office. Immediately allow the person. And if you have any hesitation, don't name that person. That means you don't trust them as much as you think you do. All right? So again, you are the coach. The players are supposed to listen to the coach. Ooh. The players are supposed to listen to the coach. Supposed to. Maybe not the 90s Cowboys, if anyone here is a football fan. Okay, that may not have happened, but they still won some Super Bowls, so that's cool. But anyway, the players are supposed to listen to the coach. And generally, that's what a power of attorney essentially does. You are in charge. You direct when this person needs to. If I'm feeling lazy and I'm just feeling like sitting at home watching TV all day, I could call my sister and say, hey, run to the bank for me. And she could do it. She might not want to do it, maybe won't do it, but she could do it. So at my direction, she should act. Or if I slip into a coma by virtue of some accident, then she can also act. okay? I'm in charge. If she starts messing around with my money, kick her off the team, all right? Kick her right off the team. Maybe too late if she clears it out and runs off to some foreign country or something, but I can still kick her off the team. That doesn't hardly ever happen, but there are bad people out there who definitely do that. But just know if you see anything that sounds like or feels wrong, you can change that document. It is not set in stone. A power of attorney is not set in stone. You can always edit it, you can terminate it, you can create a new one. Anytime you create a new one, it automatically terminates the old one. Anytime you create a new document, it terminates the old one, okay? So again, in a power of attorney financial document, what you're doing is you are giving another person the ability to handle your business, but only what is in the document can they do. So you can limit it, you can expand it, you can tailor it to your specific needs, okay? It does not get to the point where someone can use that financial power of attorney and force you to do something you do not want. That is not what you are doing. You are not giving up anything. You're not giving up your own control or your own authority over your own business. You're just giving an equal ability to a trustworthy person. Now, if you create a power of attorney, you're going to want to have some backup agents on there. Because if I got my sister and my sister alone, and she's the one who gets in a car wreck, she's not going to be able to handle my business if something happens to me, right? If I don't have an alternate or a backup on there, I might as well never created it in the first place, because there's no one named. Whole point of doing this is creating this document while you know what you're doing, so that when you don't know what you're doing, you have someone that can help you. So if all you have is one person, you're rolling the dice a little bit. So we like to have backups on there, for sure. Now, I heard a story earlier, actually earlier today in this very room. There's a local individual who supposedly doesn't have anyone. Family's gone, no spouse currently, kind of a sad situation. So it's a little bit of a struggle to figure out who to put on that document as the agent. If you find yourself in that situation, that's tough. Frankly, that's when you start looking at friends, church, social groups, if you have them. You got to reach out. It's important just to have someone on there, but don't put someone just for the sake of having someone, because if you put that someone for the sake of having someone and they're a snake in the grass, you're better off not having one at all, okay? But at the end of the day, there's got to be someone out there in your life that's trustworthy enough. Priest, I have a priest out there who's someone's power of attorney helping her while she's at the nursing home. They're pretty good people generally. No, I'm joking. Always, come on. They're generally pretty good, so that's an option, right? So there's, again, nothing that says it has to be a family member either. If you got kids or someone in the family that you don't trust, you're not obligated to put that person on your document as your agent, by no means. That being said, sometimes that can cause some problems, and I see it all the time. Oh, we got 3 kids, one of them's a bad one, but if we don't put them on here, they're gonna raise hell. Tough luck. We're talking about you and what's best for you, not what's best for them. If they're gonna raise hell, you know there's a problem, and they should not be on that document, okay? So put your own needs in front of others when you're creating these documents. It's all about you and what's best for you, okay? One other thing to touch on with the financial power of attorney that actually relates to the medical as well, which I haven't touched on just yet, but the agents that you name in there, it doesn't have to be one person. You can name co-agents. I don't particularly like going more than 2. We get into a too many cooks in the kitchen type scenario when you go up to 3 or more. 2 is usually a good number. So if you got 2 kids who you trust equally, name them both. What they can do, and what we recommend, is we give them the independent ability to act. Basically what that means is they don't both have to sign off on something. If one's out of town on a trip and the other's in town and needs to do something, we don't need to get a hold of the other one and get their signature or something. The document says they can act independent of each other. If the other's out of town, then the one who's in town can do it as well. If they're both in town, they can both do it. Be careful if they don't like each other though, all right? Because then one wants to do something, the other tries to reverse it, we get into a big time problem. So make sure they get along, make sure everyone understands what the deal is. When you've created this document, not an awful idea, maybe beforehand, to double check with them that they want to do it. Just because you're named on it does not mean you have to do anything. If I named Troy Aikman as my power of attorney agent, he's not going to do anything for me. Or Michael Jordan or someone. I could, but they're not going to do it. They don't know who I am. Right? Doesn't have to, there's no obligation to do anything. So it's not a terrible idea to verify that they're willing to act, especially if they live out of the way. I got clients who have kids who've moved out of the area and, they live in New York or something. Well, it's not as easy to do. It's easy-ish because of the way the finances are all online and everything these days, and communication's much easier. But it is a little bit more difficult, so you may just want to verify that they're willing to. One major misconception that I hear is that, why do I need to do a power of attorney? I'm married. Okay, valid question. If I didn't go to law school and get all that debt, I wouldn't know the answer to that either. Okay, but I do now. So, if you're married, you do not automatically have any legal authority to handle your spouse's business. Now, if you're on an account with them, it's there. You're co-owner, so you can do something. But if one of y'all has like a life insurance policy, that's only in your name. That's not in your spouse's name too. So just by virtue of being married, your spouse could not call up the life insurance company and get information on it or cash out some money legally, okay? You might get a foolish person on the phone who doesn't understand and allows you to. No, bad idea. They should not be doing that. There's some real big liability that comes along with that. The law does not allow for that. Why is this the case? Well, it'd be a terrible public policy to, by virtue of marriage, allow a spouse to act on the other one's behalf. Not every marriage is good. A lot of them are bad. A lot of them are really bad. Imagine if you got a really bad guy out there, and no need to get into the details, but imagine someone who's a pretty bad dude. Do you think that it would be a good idea if the law just automatically allowed him to handle his wife's business for her? Obviously not. So what they say is, if you want your spouse to do it, do a power of attorney. That simple. And you just name your spouse and now they can do it. But it's not automatic. So get that thought out of your head if it's in there, because that's what a lot of people think when they come into the office, okay? No automatic spousal power of attorney. There's no such thing, medical or financial or otherwise. Okay, financial power of attorney, I think we've covered most of the bases there. If I remember anything else I think I need to talk about, we'll get right back into it. But let's move on to medical, POA as we call them, power of attorney. A medical power of attorney is just what it sounds like. It's a power of attorney document that gives an agent the ability to handle decisions for someone else. Now the key distinction here is that a medical power of attorney only goes into effect allowing that agent to make the decision if the person is not capable of doing it themselves. Unlike the financial one, where you can give that same time ability. Hey sis, can you run up to the bank for me? Sure. In the medical context, that's not how it works. Doctor would want to hear it out of my mouth. And if I am not capable of telling a doctor what I want, then and only then will they listen to the power of attorney agent, okay? So, if you're laying in a hospital bed, sick, tired, coming up on the end, but you can tell the doctor what procedure or what medicines you want, your agent in your document cannot come storming into the room, waving that around, telling the doctor not to listen to you. That's not how it works. Because you can tell the doctor what you want, it's your body. If you're in a coma, can't tell the doctor what you want, different story. Then your agent jumps into action, handles your business for you on the medical side of things. Now, common misconception, again, having the power of attorney, be it financial or medical or otherwise, does not give the person the ability to make you do something you do not want to do. Should I do like my teachers did in school? No, I'm joking. Okay. You cannot be forced to do something you don't want to do. And the main deal that I see in my office is don't want to go to a nursing home, okay? Don't want to go. And I get it, everyone wants to live at home. That makes sense. An agent in a power of attorney, financial or medical, is not legally allowed to force you to leave your house. That is a constitutional right that every citizen in the United States has. Come and go as you please. Be where you want to be. Do what you want to do. You're not allowed by law as a competent person to give someone else that decision making over you, right? You can't do that. And they can't use this document to do that over you. So if anyone ever tries that to someone you know, or even to you, they're not allowed to. The only person that can do that is a guardian. A guardian, okay? If you are under a guardianship, that means you have gone through some sort of big, long, expensive court process where you've been stripped of your rights because you are deemed to be incompetent, all right? No one in here needs a guardianship, okay? So no one in here can be forced to go somewhere against their will. Only a guardian has that ability. Having a power of attorney in place helps prevent the need for a guardianship, okay? Because if you've taken care of that decision making for everything other than where you're gonna be allowed to go, there's pretty much no need for guardianship. Only time you really need to is if there's someone who is in a terrible mental condition and literally cannot be at home without becoming a massive danger to themselves and to the community, and they refuse to leave. And you probably can picture scenarios where that is a major issue. If they're not under a guardianship and they need to be somewhere else, then it makes sense for a guardianship. It's a very extreme situation that you should be looking at that option. But if you've got your power of attorneys out of the way, that gives your agent or your players the ability to handle everything that you could do other than decide where you live. So again, let's not go out there thinking that a power of attorney, medical or otherwise, or financial, allows somebody to make any sort of living arrangement decisions for you. It simply does not. Legally not allowed. Okay. Continue, or we're done? Oh my gosh, I was about to get to the good stuff. Okay, no? All right. Okay, well, yeah, I'll be available for questions then. Anything anyone wants right now, questions, or anyone have any at the moment? Right up front.
If the financial institution doesn't want to take a power of attorney, is that?
Okay, so the question was, if a financial institution does not want to accept a power of attorney, what then? That's a tough one because there is no law that states outright, you must accept this document, okay? The whole idea behind having it is that it's understood that this person is allowing the individual they're naming to handle their business. But it doesn't also say in the statutes anywhere, and if this is presented, this person must accept it. It's just very common practice to accept it. Now, if you're a financial institution and someone gives you a copy of a power of attorney, for example, If you have a reason to believe that it may be false or perjured, or not perjured, what is it called when you, forged, yeah, forged, something along those lines, then you have a valid reason not to. Matter of fact, there actually was a law, I think, that came into place in 2017 saying that banks must accept copies of powers of attorney unless they have a reason under a list of 10 reasons not to. But there's no real concrete, like are you gonna sue the bank for not accepting it? It just becomes really expensive. If they're gonna give you problems, I'd recommend calling your lawyer and then letting them handle it because they should be accepting it.
The instance I'm talking about is if you're buying a car and her husband's overseas.
If you're buying a car,
You're trying to get a car for the family, the husband's overseas working.
husband's overseas,
He's giving you power.
he's giving you the ability and you're trying to,
Institution said no. He has to
the bank would not finance it basically under his name?
They wouldn't let the wife who had the power of attorney for the husband sign his name.
Okay, that is,
He was doing something.
that sounds like something you should probably talk to the lawyer who drew it up and have him or her communicate with the bank and let them know that they're incorrect. Okay, that's what I would do. Yeah, it's a tough situation when there's a person who refuses a valid power of attorney because again, there's no governing board of people that are going to drop out of the sky and force them to right then and there. There's going to have to be some sort of process to get them to accept it. And usually just a threatening letter from a lawyer will help. Yeah, I mean, I think you'll be fine, but you're going to need someone to type something up for you and get them to listen. Anyone else?
Okay, you have a stock account in your name and there is a car wreck or whatever. Your spouse will not be able to call and say, hey, I need this money for expenses or whatever. Right?
Okay, so the question was if I have a stock account, I'm guessing with like Merrill Lynch or one of the financial institutions in your name only. He was clarifying a spouse could not then call them after a car accident or something and get access. No, because it's not in her name. It's in your name, so only if she could present them with a valid document that you signed while you were competent, saying that she can handle your business, and then they reviewed it and made sure it was valid, would they then allow her to handle your business? If her name is on the account, then of course she could though. Okay, I'll be over here in that corner if anyone wants to ask something else. Thanks, guys. Thank you.